like I said, we'll get to as many as we can. So welcome to our presentation. We are giving an overview of California's COVID-19 Tenant Relief Act, specifically focusing on Senate Bill 91.
Hi, everyone. Good afternoon. I'm Olivia Dopler. As Anne mentioned, I'm an associate at Adair, MacDonald and Partners. And my practice area is primarily focused on representing both landlords and tenants in residential and commercial disputes. I handle all sorts of matters, including rent board mediations and arbitrations, superior court matters, bringing and defending unlawful detainer actions, and just generally keeping up to date with all these new changes in the law.
And hi, everyone. My name is Anna Liu. I'm also at Adair, MacDonald and Partners. I'm a partner there. I also practice real estate litigation and landlord-tenant law, handling all types of matters representing property owners primarily and tenants, both in residential and commercial situations. I also handle other real estate matters like partitions, buyer-seller disputes, co-owner disputes. All right, let's dive right in. So the focus of our presentation today is on Senate Bill 91, which, among other things, it has extended last year's AB 3088, the COVID-19 Tenant Relief Act of 2020, also called CITRA. And this legislation primarily provides protections for tenants who have been impacted by COVID-19. And importantly, it adds just cause eviction protections for almost all residential tenancies. And that's through a law that was passed a couple of years ago called AB 1482, which we'll dive into. And then SB 91 also provides a rent relief package for landlords and tenants. So in our presentation today, we will cover what the eviction protections are, the legal procedures to evict tenants and recover unpaid rents. We'll touch on some practical pointers for those of you who are representing landlords or tenants or who are landlords or tenants. And then we'll share some of our considerations as we move forward with this legislation through the pandemic. Senate Bill 91 was signed by Governor Newsom on January 29th of 2020, and it went into effect right away. Like I said earlier, it extended AB 3088, the eviction moratorium, and AB 3088 was a big packet of legislation. Later in our presentation, Olivia will touch on, over 20 different laws that AB 3088 impacted. But for purposes of our presentation today, we're just going to focus on CITRA. SB 91 also created a rental assistance program to assist landlords and tenants with COVID-19 debt, which I'll discuss and how that's being implemented through the state. And the bill created new rules related to lawsuits and small claims actions for COVID-19 debt, basically delaying when a property owner can sue a tenant in court to collect the money or collect damages. And like I said earlier, we're just going to focus more narrowly on Senate Bill 91 and how it extended AB 3088. So turning it over to Olivia, she's going to get us started on some of the key components.
Thanks, Anna. So there are several key components of CITRA. We're going to touch on each of these today. Just as an overview, one of the key components is that there were substantial eviction protections for non-payment of rent, and that also includes new procedural requirements for non-payment of rent evictions. In addition, CITRA extends just cause for eviction protection to nearly all residential tenants until June 30th, 2021. And this is important because even if tenants would normally have, if the tenancy would normally have an exemption from eviction protections under AB 1482 or a local law, SB 91 is going to give those tenants eviction protections through June 30th of 2021. Another key component is that there are limits on local eviction moratoriums. So we'll cover some of the preemption rules under CITRA. There is a new informational notice to tenants regarding CITRA that is required for landlords to provide to any tenants that missed a rent payment from March 2020 to February 1, 2021. And then finally, there are several miscellaneous other new tenant protections that we will cover. Anna, can you go ahead and flip to the next slide? Okay, so the COVID-19 Tenant Relief Act provisions are currently in effect through June 30th of 2021. That was recently extended under SB 91, and of course it could be extended again. And another key thing to note under Citra is that nothing in the law relieves a tenant of liability for unpaid rent. However, there are provisions under SB 91 that delay a landlord's ability to file actions for unpaid COVID-19 rental debt. Okay, so what does Citra apply to? Citra basically applies to all residential tenancies. Again, tenancies that would otherwise be exempt under AB 1482 will still fall under the protections of Citra. Basically, the only exceptions are as follows. Commercial tenants do not have protections under Citra. Citra only applies to residential tenancies. And commercial tenants are defined as a person or entity that hires any real property in the state that's not a dwelling unit. Citra also does not apply to corporate rentals. So basically, when the renter is not a natural person. And then finally, Citra does not apply to transient occupancy. So basically, this is going to mean guests of hotels and motels. Okay, the next question is what rental payments are covered under Citra? So Citra applies to all rental payments that became due from March 1, 2020 through June 30, 2021. Rent payments are defined in Citra as well, and they include not just rent, but also any other financial obligation of the tenant under the tenancy. So this is going to include other payments, such as utilities payments and other fees that are provided under the rental agreement. That will all be considered a rental payment, and the tenant will have protections under Citra that would prevent the landlord from terminating the tenancy unless the Citra provisions are complied with. Payments that became due before March 1, 2020 are not covered under Citra. However, they may be covered under local or federal eviction moratoriums. Under Citra, rent payments that came due during the covered time period are broken up into two different protected time periods. So the first time period is called the protected period, and that relates to payments that became due between March 1, 2020 and August 1, 2020. That is unchanged by SB 91. That was the same time period that was set up under AB 3088, and that has stayed the same. Anna, can you switch back? Thanks. The other time period is the transition time period, and that applies to payments that became due from September 1, 2020, and now goes all the way through June 30, 2021. SB 91 extended this from the end of January all the way through the end of June now. We'll get into some more details here in a few minutes relating to the procedural requirements when it comes to 15-day notices. But it's important to note that if the landlord had served a 3-day notice to pay rent or quit back in the early days of the pandemic, that notice is going to be invalid now. If the landlord served a notice to cover rent that became due between March 1, 2020 and August 31, 2020, that is also likely out of compliance with the new Citra rules. If landlord served a notice between September 1, 2020 and January of this year, and it was in compliance with AB 3088 when it was served, that should remain effective now. Even though SB 91 extended the transition time period that was set up under AB 3088, as long as notices were served basically in January or before, and they complied with the AB 3088 rules, they should still be effective now. All right, and I'm going to turn things over to Anna now to discuss some of the notice requirements.
Perfect, thanks, Olivia. And sorry that I think the chatter was me. My partner's on the phone, so I text him to talk a little quieter. Sorry about that, everyone. Okay, moving on. So this is really important. There is a deadline here that everyone needs to be aware of. February 28th is the deadline for serving a new notice. So there is a mandatory informational notice with specific language. We put the CCP in there. It's 1179.04. So if you have a tenant, or if you are a tenant, or if you are a landlord, or if you're representing a landlord who has a tenant who missed rent payments between March 1st of 2020 and February 1st of 2021, you have to serve a brand new mandatory informational notice under Citra on the tenant with very specific language, notifying the tenant of this new law and of their rights. If you don't serve that notice, the law doesn't exactly say what happens, but our interpretation is that you are not going to be able to move forward with serving the tenant with a 15-day notice to pay rent or quit, and then subsequently move forward with an unlawful detainer action if the tenant doesn't comply. So this mandatory notice is key. Again, February 28th, the last day of this month, is your deadline to serve the notice. And that's again for tenants who have not paid rent or missed any rent payment from March 1st of last year through February 1st of this year. Previously under AB 3088, it was August was the old deadline, but SB 91 has extended that to February 1st. You can serve this Citra notice by the manner prescribed in Code of Civil Procedure, section 1162, or by mail. So what we're doing in our office as a practical matter is we are serving these notices for our clients by both first class and certified mail. Like we put in the slide, a landlord can't serve a new 15-day notice to pay rent or quit until this informational notice has been served. We get a lot of questions that say, well, what if I miss the deadline? What happens? We don't have any court cases yet that have litigated this issue. So we're telling you now before the deadline, don't miss it. But if for some reason you do, talk to an attorney, we can try and help you troubleshoot through that. I'm going to be covering what is required for 15-day notices. So all 15-day notices to pay rent or quit must comply with all of the following items. So the time period that the tenant may pay the rent or turn over possession of the property must be 15 court days, so not calendar days. And as we all know, court days do not include weekends and court holidays. So there's extra time that tenants have to pay to comply. The 15-day notice to pay rent or quit also needs to specify the amount of rent demanded and the date each payment became due. The 15-day notice has to advise tenants that the tenant will not be evicted for failing to comply with the notice, so long as the tenant delivers a signed declaration of COVID-19 financial related distress. And that declaration must be given to the landlord on or before the date the 15-day notice to pay or quit expires. The notice must also include specific statutory language required, and it has to be in at least 12-point font. And again, what language you use depends on what date the notice was served, and this is new under SB 91. The 15-day notice must also include a blank declaration of COVID-19 financial distress form, and the language of the 15-day notice must be in the same language the rental agreement was negotiated in. So usually it's going to be English. Our office, we have some leases and clients who have negotiated their lease in Chinese or in Spanish. So if that is the case, then your notice must be in the language the lease was negotiated in. There are different time periods that are at play depending on when rent was owed and when it was missed. So the first time period is called the protected time period. And this is the same as AB 3088 Citra. This has not changed by SB 91. So if a tenant missed any rent payment that was due between March 1st of 2020 and August 31st of 2020, that's called the protected time period. And it's called protected for a reason. If a tenant complies with this, they cannot be evicted for missing a rent payment between those two dates. So again, you'll have to serve a 15-day notice. And again, in the notice, you have to advise tenants that they cannot be evicted for failure to comply with the notice if the tenant gives the landlord a signed declaration of financial distress. And we will later get into what actually goes in that declaration. The statutory language is very specific. It's in the statute 1179.03b subsection 4. And in our packet of materials that will be distributed after this program, we did include the PowerPoint slides, so you'll have all the slides, and then we also included the statutes, so you'll have those to reference as well. There's a special category for high income tenants, and Olivia will get into what is a high income tenant later in the presentation, but just know that for high income tenants, there's an additional requirement that the high income tenant must submit supporting documentation describing their financial distress. If the tenant is not a high income tenant, then no supporting documentation is required. So I get that question a lot, and I always try to tell folks, just remember that if it's a high income tenant, you can ask for documentation. If the tenant is not high income, they don't have to give the landlord any evidence of what their financial distress is. If the tenant does provide the signed declaration certifying under penalty of perjury that they have experienced COVID-19 related financial distress, and if they're high income, they've given documentation, then the landlord cannot evict for non-payment of rent owed during the protected time period. So they can never be evicted if they comply and if they owed rent for this time period. Don't confuse that with not being able to recover the rent. The rent is still owed and due, they just can't be evicted for non-payment. Next is the transition time period. So this is altered by SB 91. The transition time period is September 1st, 2020 through June 30th, 2021. Similar requirements to the protected time period, except there's an added 25% payment requirement. So going in order, again, you have to serve a 15-day notice if a tenant missed rent between September 1st of last year and June 30th of this year. The notice, must again have that very specific CCP 1179 language in it, and high income tenants will have to provide supporting documentation. And this is the new part. This is or I shouldn't say new because it was the same as AB 3088, but it's different than the protected period. If the tenant provides the signed declaration of financial distress and pays at least 25% of rent owed for this time period, then the landlord cannot begin proceedings for an eviction based on non-payment of rent. So the 25% payment must be made at any time before June 30th of 2021. The tenant just has to pay at least 25% of the rent, and the landlord can't move forward with an eviction based on non-payment. So now I'll turn it over to Olivia, who will get into what needs to be in that tenant declaration.
Thanks. So I'm going to go over some of the finer points relating to the declaration of COVID-19 financial distress. So first of all, the CITRA statute actually lays out the exact language that needs to be put into these declarations. And the law says that the landlord needs to provide a blank copy of this declaration with all 15-day notices to pay rent or quit. So basically what the landlord's going to want to do is actually just copy that language exactly out of the statute, put it on a form, and give the form, a blank copy of that form to the tenant along with the 15-day notice so that the tenant can return it to the landlord if they want to assert protections under CITRA. In order to actually claim the protections under CITRA, the tenant is going to have to certify the following things. First of all, the tenant is going to have to certify that they're unable to pay their rent or other financial obligations under the lease because of one or more of the following reasons. This would include a loss of income caused by the COVID-19 pandemic, increased out-of-pocket expenses directly related to performing essential work during the pandemic, increased expenses directly related to health impacts, childcare responsibilities, responsibilities to care for an elderly, disabled, or sick family member that's related to the pandemic, and that limits the ability to earn income, increased cost for childcare or attending to an elderly, disabled, or sick family member directly related to the pandemic. And then finally, a catch-all provision for other circumstances related to the COVID-19 pandemic that have reduced the tenant's income or increased their expenses. So the key here is that it does have to be related to the pandemic in one way or another, but there are a lot of categories, as you can see here. The other thing the tenant has to certify is that any public assistance, including unemployment insurance, state disability insurance, paid family leave, any of that kind of thing that they have received since the start of the pandemic does not fully make up for their lost income or their increased expenses. The tenant is going to have to fill out this declaration. They do have to sign it under penalty of perjury, and then they have to return it to the landlord.
I'll just make a really quick point for number 6 on our slide. Our office is working on these types of cases, and we're evaluating declarations as we receive them. And number 6, like Olivia said, is a catch-all. It's really broad. And I think a tenant can make the argument, I think a lot of people can make the argument that they have somehow had a financial impact related to COVID-19. So as a practical pointer, that is a really broad category. And for that reason, it's pretty easy for tenants to submit the declaration and meet this requirement.
Yeah, totally agree with that. I think most people are going to have some sort of argument that they had some impact due to COVID. Okay, so there are a few other components to the declaration as well. First of all, no supporting documentation is required unless the tenant is a high income tenant. So basically, landlords cannot ask the tenant to actually document what the tenant is saying. The tenant can basically fill out this form, return it to the landlord, and unless the tenant is a high income tenant, the landlord's kind of stuck with what the form says. With that said, do keep in mind that local eviction moratoriums and ordinances may require tenants to provide supporting documentation, but that would be separate from the SB 91 protections. And the other thing too, we'll get into this in a few minutes with the other laws, but all applicable laws would have to be complied with. And if the tenant can get protection under CITRA, then they would be protected from eviction. Another key thing to note is that there are translation requirements for the declaration. If the lease was negotiated in a different language and a copy of the lease was provided in a different language, then the landlord is also required to provide a copy of the CITRA declaration in that same language. There are supposed to be forms available that have these translations for certain select languages that are set forth in CITRA. There are multiple methods through which the tenant can return the declaration to the landlord, and these are supposed to be set forth in the 15-day notice so that the tenant knows how they can return the declaration to the landlord. These could include any of the following methods. For one, the tenant can return the declaration in person if the landlord indicates an address in the notice where the tenant can return it. The tenant can also return it by email if the landlord indicates an email address to which the declaration can be emailed. The tenant can return it by US mail, again, at the address that the landlord indicates in their 15-day notice. And then finally, the tenant can return it through any of the means that they could use to pay the rent, if that would apply. So finally, one other key thing to note here is that one tenant submission of the declaration is going to protect the entire household. If there's 4 people living in the household, it's not necessary that all 4 tenants return one of these declarations. If one tenant returns the declaration, then the household is going to be protected. Okay, so as I mentioned, there is a documentation requirement for high income tenants. But only high income tenants are required to provide supporting documentation of their financial distress. A high income tenant is defined as a tenant with an annual household income of at least $100,000 or 130% of the median income for the county in which the property is located, whichever one is higher. So I did pull the figures here for Contra Costa County, and the 130% median income is going to be the higher range. So these figures would apply. In Contra Costa County, the 130% median income is just over $108,000 for one person, 123,000, or actually closer to 124,000 if the household has two people, and close to 140,000 if the household has three people. So basically, if the tenant makes more than those amounts, then the landlord can require the tenant to also provide documentation to support their Citra declaration. If the tenant does not make those amounts, then again, the documentation is not required. It should be noted that the term household includes all lawful occupants, including minors. And landlords have to have proof of income showing that the tenant is a high income tenant before they serve the 15-day notice demanding the supporting documentation. And basically, landlords can't go out now and ask the tenant for proof of income in order to fulfill this requirement. And the landlord can't go out now and try to independently verify it. The landlord needs to have already had this documentation showing that the tenant is a high income tenant on file before we're getting to this point here. Finally, supporting documentation that the tenant can provide to fulfill the requirement includes any form of objectively verifiable documentation that demonstrates the COVID-19 related financial distress. It can include things like bank records, tax returns, a letter from an employer, unemployment insurance records, medical records, childcare records, notices of school closures, all kinds of things. And again, as a practical tip here, as Anna noted, when we're dealing with these cases, we see basically all sorts of claims from tenants to try to get protections under Citra. And this is another one of these catch-all provisions here that's really, really broad. And the term objectively verifiable documentation could conceivably include a lot of types of documentation. So it's just something that landlords want to watch out for and may require some analysis.
I agree, and I'll just add one real quick point. Olivia and I had an interesting case where the landlord asked us, when my tenant applied to live in the unit, they reported an income, I think, let's say 100,000. And, if Contra Costa County, the minimum threshold is 108,000 for a one-person household, high income, the question was along the lines of, well, presumably they got a raise over, the last 10 years. So are they high income now? And we had to tell that client, no, your tenant is high income if you had that information at the time the tenant applied. So that was kind of an interesting nuance that the landlord must already have the tenant's application showing their income before they can be deemed a high income tenant.
Okay, so what happens when the tenant provides a declaration? The tenant is going to be protected from non-payment of rent evictions until at least July of this year if the tenant provides the declaration and then the supporting documentation if they're required. As Anna had noted previously, there are these different rules for the different time periods. So again, just quickly jumping back to that, if the rent payments that are at issue fell between March 1, 2020 and August 31, 2020, then the tenant is never going to be able to be evicted for the non-payment if they returned this declaration. And for the transition time period rental payments, it's going to delay the eviction proceedings. And if the tenant can pay at least 25% of the rental payments by June 30th, then the landlord is never going to be able to evict for that remaining 75%. The landlord would then have to either go to small claims or file a regular civil action for the other unpaid rent. Can you jump us to the next slide? Yes. Okay, so on the other hand, what happens if a tenant misses their deadline to provide a declaration? The tenants have until the date that the 15-day notice expires to provide the landlord with the COVID-19 related financial distress declaration. However, this begs the question, what happens if the tenant misses that deadline? If the tenant misses the deadline, the landlord can go ahead and file an unlawful detainer action in Superior Court. However, there is a provision in Citra that would allow the tenant to file the declaration with court within the same time period that they have to respond to the summons and complaint for that unlawful detainer action. So this basically gives the tenant at least another potential opportunity to provide the Citra declaration even after an unlawful detainer action has been filed. Now, it's not necessarily or automatically going to be accepted. The court is going to schedule a hearing, and the tenant is going to have to explain to the judge why they failed to timely provide the declaration. And the court would look at this under a CCP 473B standard. Basically, was there some sort of mistake, inadvertent, surprise, or excusable neglect that explains why the tenant failed to timely return the declaration. If the court finds that the tenant can establish grounds under CCP 473B, that they had an excusable reason for failing to provide the declaration, then the court would actually go ahead and dismiss the unlawful detainer action, though a tenant would not be considered the prevailing party in that situation when it comes to awarding attorney's fees. So again, as I mentioned, the court would look at whether or not there was mistake, inadvertence, surprise, or excusable neglect. And depending on which time period the rent payments are unpaid for, one of two different things would happen. If the rent payments fell during the March 1 through August 31, 2020 time period, the protected time period, the court will just dismiss the cause of action altogether. And the landlord, again, is never going to be able to evict for that non-payment. The landlord would have to go to small claims or regular court to recover that unpaid rent. If it's before July 1 of 2021, likewise, the court would dismiss the unlawful detainer action if these rent payments fell due between September 1, 2020 and June 30, 2021. This is for the transition time period. And what that's basically going to do is give the tenant more time to try to make up the 25% rent payment that they would have to pay by the end of June. Now, say we're in a situation where we've already gotten to July or beyond, and the tenant for some reason hadn't returned their Citra declaration and an unlawful detainer action had been filed. In that circumstance, the court would only dismiss the unlawful detainer action if the missed payment fell due during the transition time period, and the tenant can actually go ahead and pay the 25% payment. And the court would have to give the tenant at least 5 days to pay that. All right, I'm going to turn things over to Anna now to cover AB 1482 and the expansion of just cause under Citra.
Great, thank you, Olivia. So we're going to switch gears from declarations and notices and get into the eviction protections that have been extended under SB 91. So to give everyone a refresher, AB 1482 was a bill that was passed back in 2019 by the California legislature. It's called Assembly Bill 1482, also known as the Tenant Protection Act. It became effective on January 1st of 2020, and it does two main things. It imposes statewide rent control and it imposes statewide eviction control on certain properties. For purposes of our presentation and SB 91, AB 1482's applicability only covers the eviction control portion. It doesn't touch rent control. But that's not to say that you don't have to be aware of it. It's just that for right now, we're going to be covering why there are now just cause requirements that have been enacted under SB 91. So as I mentioned, the rent control part of 1482, just as a refresher, it imposes a limit on annual rent increases that a landlord can impose on certain properties, and there are exceptions. And for purposes of SB 91, this is the key part, number 2 on our slide. It requires landlords to have just cause in order to terminate a tenancy. and we'll get into what the just cause reasons are. So under Citra, all landlords who are going to terminate a tenant's tenancy must have a just cause reason under AB 1482 to terminate a tenancy before June 30th of 2021, and that's an SB 91 extension. And I'll go ahead and get into what are the just cause reasons. They're broken up into two categories, fault-based and no fault-based. So the fault-based reasons are when, a tenant did something wrong, like nuisance, breach of the lease, non-payment of rent. And the no fault-based include things like the Ellis Act, when the landlord wants to go out of the rental market, or if the landlord wants to recover possession, let's say to move in. They have their own reasons, but the tenant has not done anything wrong. These are the fault-based reasons under AB 1482 for eviction. Now, I'll just say that you have to check your city, county to see if there are any requirements that alter this, and I will get into Contra Costa's current eviction moratorium and rent freeze. But for purposes of AB 1482, what you see on the slide are all of the at-fault reasons listed under AB 1482. Just to name off a few, non-payment of rent, but you have to watch out for Citra, breach of a material term of the lease, and the notice does require that you basically give a pre-warning. So you have to give the tenant an opportunity to correct the violation before you even serve a notice to cure or quit. We do a lot of that in our office. We'll serve a demand letter to cure the behavior before we actually serve the formal termination notice, and it has to be cure or quit. Nuisance, criminal activity, or illegal use are other examples. Committing waste. This one's interesting. Failure to renew lease after written request by the owner. That's one of the at-fault reasons under AB 1482. Refusal to allow legal entry. So if an owner is serving a Civil Code Section 1954 notice of entry and the tenant refuses to let the landlord in, that can be one of the just cause reasons under AB 1482. An employee's failure to vacate after employment has been terminated, and failure to vacate after providing the owner written notice of their intent to vacate. So tenant gives notice, they back out. That's another at-fault reason under AB 1482. I'm going through these a little quickly just because we have limited time, and Olivia and I actually did a presentation on AB 1482 last year for the California Lawyers Association, so that's available too in case you need to get into this in more detail. The no fault reasons for evictions, there are four. The first one is an owner or relative owner move-in, and the definition of relative is very limited. So it has to be the owner, their spouse, domestic partner, children, grandchildren, parents, or grandparents. And this is actually the same definition as the Contra Costa County's eviction moratorium for Contra Costa County's exception, which I will get into later. And it's important to know that you can only utilize the OMI option if you have that language written in your lease. So if you have a lease that was entered into on or after July 1st of last year, then you must have this OMI provision in your lease allowing you to do so. Otherwise, you won't be able to utilize that option. Number two is the Ellis Act, withdrawing the residential unit from the rental market. We could do a whole hour segment on the Ellis Act eviction, but just suffice to say that that is one of the no fault reasons under AB 1482. And the third one is if a city or county agency requires that the unit be vacated due to uninhabitable conditions. And the last one is the landlord's intent to demolish or substantially remodel the residential real property unit. And substantially remodel has a specific definition. We put it up on the slide to keep it simple. The remodel or renovation work has to be substantial. It can't just be a cosmetic upgrade, like, I want to touch up some paint, or I want to make some minor repair work to the floor. The intent to demolish or substantially renovate must be, abating hazardous material like lead-based paint or mold or asbestos that requires the tenant to actually vacate. And there is an exception for Citra. This is different than AB 1482. This is not present in AB 1482. This is a specific Citra exception that Citra limits evictions for demolition or substantial renovation to circumstances where it's necessary to comply with health and safety laws and laws governing the habitability of the unit. I wanted to quickly touch on relocation payments for no-fault evictions under AB 1482. So normally under AB 1482, a landlord who is going to evict a tenant for a no-fault reason, regardless of the tenant's income, they must pay relocation money. The relocation money is either 1 month's rent or waiving the final rent. But Citra extensions don't require a landlord to pay relocation when terminating the tenancy for a no-fault reason. So what I mean by that is if the property wasn't otherwise subject to AB 1482, let's say, for example, because it's new construction, it was built, last year, then a landlord does not have to pay relocation money if they're terminating the tenancy because of Citra. So just to kind of clarify that, AB 1482 normally, for example, one of the exceptions is it only applies to properties that are built prior than 15 years ago. It's a rolling 15-year window. But because of Citra, AB 1482's protections are going to apply to all residential tenancies. And there are just a couple of exceptions, which I will get into. Back on the relocation, if a landlord is otherwise required to pay relocation assistance under AB 1482 or another law, those requirements still apply. So for example, in San Francisco, we have our rent ordinance, and if you do an owner move-in, you're required to pay relocation money. So Citra does not change that. The landlord may offset the tenant's COVID-19 rental debt against their obligation to assist the tenant to relocate. And the example we included on the slide is what I was mentioning before. So if it's a new construction built last year, it would normally be exempt from AB 1482, but AB 1482 temporarily applies through June 30th of 2021 because of Citra, but relocation payments aren't owed, again, if it's a no-fault termination. This is the exception I mentioned. It's for single family homes and condos. So Citra has a very, very limited exception from just cause, and on the slide, those are the requirements. So the property must be a single family home or condo, and the owner must be in the process of selling the unit. As long as the owner and the buyer have a contract for sale, and the buyer must intend to own or occupy the unit. So it's really specific, and it only applies, this exception, if a sale of the single family home or condo is pending at the time of service of the termination of tenancy notice. In our office, we haven't seen this situation apply yet because we've had clients say, I'd like to sell my property, my condo, and I'd like the tenant to move out. But we've advised them that this exception is very narrow and that you already have to be in contract to sell at the time you serve the termination notice, and the buyer has to state their intent to own or occupy. And most people aren't happy with that because they would like to market the property as vacant before they even get it on the market. I'll also add that exception only applies so long as the single family home or condo is not owned by a real estate investment trust or a corporation or an LLC in which at least one member is a corporation, and the landlord has already complied with AB 1482's requirements to give written notice of that exemption to the tenant. And as I said, the landlord or seller is already in contract with a buyer who intends to own or occupy. The owner must give written notice to a tenant if they're claiming this exemption. The language is on the slide, and if the tenancy existed before July 1st, then the notice is not required to be in the rental agreement. But if the tenancy renewed or commenced after July 1st, this notice must be in the rental agreement. This does not apply if the tenancy was already terminated before March of last year, and the notice must have expired before March, and the landlord should not or could not have waived the notice. So, for example, if they accepted any rent payment after they served this notice. So we're going to switch gears, and we're going to get into how Citra interacts with other laws like local moratoria, the CARES Act, and the CDC.
Sorry about that. Okay, so as I mentioned earlier, SB 91 does have some preemption provisions in it. And these relate to how SB 91 interacts with local laws. And what SB 91 says is that if there was a local eviction moratorium that was adopted as of August 19, 2020, it can remain in place and it can stay in place until the end of its term. However, if the end of its term would expire before June 30, 2021, it cannot be extended or renewed until July 1, 2020. In addition, new moratorium cannot be adopted after August 19, 2020 if the effective date is prior to July 1, 2021. So basically, new local moratoriums cannot be put into place before July 1. So reading that part, it sounds like SB 91 has a really, really broad preemption aspect to it. However, on a closer look, there is basically a big hole that you're seeing a lot of local jurisdictions use to get around this whole preemption issue. And Anna's going to cover some of the Contra Costa updates in a few minutes here. Contra Costa recently enacted a new moratorium that was adopted after August 19, 2020. And it appears that they're doing so under this exemption. And basically the exemption says that local governments can still adopt, amend, or enforce ordinances that require just cause for termination of the tenancy, so long as the provision doesn't apply to rental units. So long as the provision after August 19, 2021 doesn't apply to rental payments that came due between March and June. And basically what they're saying is you can't touch the non-payment issues that are covered under Citra. You can't adopt local moratoriums that conflict with the Citra rules for non-payment evictions. But if you set up a local rule and you frame it as a just cause ordinance instead of a COVID-19 eviction moratorium, there's basically this big, big hole where you can kind of get around this whole preemption issue. So we're seeing a lot of cities and counties get around things like that. And of course, these rules are new. It remains to be seen how the courts might start interpreting some of these provisions, but at least seemingly there is a big hole where local governments can get around the preemption issue. Okay. So as I mentioned, the one exception to that is that local governments really cannot modify the non-payment of rent rules that are set forth in Citra. Any provision of a local eviction moratorium that allows a tenant a specified period of time to repay COVID-19 rental debt is subject to all of the following rules. If the local ordinance requires repayment to commence on or before August 1, 2021, then any extension after that date, made after August 19, 2020 shall have no effect. So basically, if local cities try to come in and want to extend the date for non-payment cases, they can't do it now. SB 91 is going to control. If they weren't already in effect, that can't be touched. If there was a local ordinance that was already in effect, though, and it was made before August 19, 2020, it would remain in effect, but SB 91 does still impact repayment periods. And if the local ordinance required repayment to commence on a date after August 1, 2020, or if the local moratorium tied repayment to the proclamation of the state or local emergency, then repayment periods are deemed to begin on August 1, 2021. So again, kind of what does this mean practically? We've seen several cities and counties say that repayment periods are tied to the declared local emergency, and repayment does not have to begin until after the local emergency ends. And SB 91 does override that. And it says that the repayment period has to begin on August 1, 2021, even if the local ordinance says otherwise. In addition, no repayment period can last beyond August 31, 2021, with respect to covered rental payments at least. And again, these would be the covered rental payments under Citra. SB 91 does also touch on some 15-day notice requirements with respect to local eviction moratoriums. And basically what SB 91 says is that 15-day notices only need to comply with CITRA requirements. Landlords do not have to comply with language requirements under local laws. So if a local ordinance says that certain language is required in a non-payment notice, SB 91 overrides that, and only the CITRA language is required. Now, there is a caveat that landlords do still have to comply with substantive requirements. So for example, if a local law would require that that the landlord file a copy of the notice with the rent board, substantive requirements like that do still need to be complied with. And then finally, there is a provision under SB 91 that states that the 1-year period in state law to serve a notice to pay or quit for rents owed is told during any period that a state or local law prohibited serving the notice. So obviously there's long time periods here where landlords may not be able to serve notices to pay or quit, whether it be because of a local moratorium or state rules. And if the landlord was prohibited from serving the notice to pay or quit, the typical 12-month time period that is applicable to non-payment of rent notices does not apply. And just for a quick refresher here of what I'm referring to, there is a rule under state law that says that landlords can only demand up to the last 12 months of unpaid rent in a non-payment notice. So it would toll that 12 months. Okay, and I'm going to turn things over to Anna now to discuss Contra Costa County rules.
Perfect. Thanks, Olivia. And I'm going to kind of fly through these because I know we're short on time and there's so much material to cover, and we want to get to some of the questions that have come in. So I'm going to move through this a little bit more quickly, but I did include the statute in your materials packet, so you will be getting a copy of that. And also, again, the slides are going to be distributed, so you'll have these slides available as well. So Contra Costa County extended their urgency ordinance. It's number 2021-04. You'll get a copy of it. We included it in the packet. It is effective February 1st of 2021 through June 30th of 2021. And basically what the Contra Costa County eviction moratorium says is that it prohibits no-fault evictions of residential tenancies. And there are those 3 exceptions if there's an owner or owner move-in. And again, the immediate family members are spouse, domestic partner, children, grandchildren, parents, or grandparents. So no brothers, no sisters, no aunties, uncles. The eviction must also be necessary to protect the owner or another tenant's health or safety. That's the second exception to the no-fault eviction moratorium. And the third exception is that the owner wants to perform the Ellis Act. The county ordinance also prohibits landlords from evicting tenants because they have allowed family members to live with them due to the pandemic. So if your lease says no subletting and your tenant brings in their cousin because the cousin needs some help during the pandemic, this county ordinance prohibits that type of eviction. And all of the citations to the ordinance are up on the slides. What rental tenancies are covered by this ordinance? It applies to all residential tenants, including those living in mobile homes in Contra Costa County. There's also some protections for commercial businesses, which I'll touch on very quickly. The commercial tenant protections, the small business must have 100 employees or less. They must have 15 million or less in average gross annual receipts over the past 3 years. The principal office must be in California. The commercial moratorium expires March 31st, 2021. Unless it gets further extended. There are a few exceptions. The rent freeze. So there's also a rent freeze in Contra Costa County, meaning landlords cannot serve rent increase notices right now, at least through June 30th, 2021. The exceptions are on the slide. So if the property is otherwise exempt under Costa Hawkins, like if it were a single family home built after 95, then this does not apply. There's also some other exceptions for specialty housing, nonprofits, licensed care facilities. This doesn't apply if there's an automatic rent increase in the lease made before March 16th. So we have seen some leases where there's an automatic rent increase that would kick in, and this would not apply if that's the case. Keep in mind that there could be other rent increase limits imposed by a specific city. And it does protect the landlord's right to raise the market to rent, raise the rent to market, excuse me, on a unit once a tenant moves out. So in other words, I'm talking about vacancy decontrol. On the rent increase, just watch out for the anti-price gouging state law that's triggered under Penal Code Section 396 whenever there's a declared state of emergency. Hey, JR, welcome.
I made it.
Anything you want to add on the Contra Costa part?
Well, I have a question for you, but I didn't want to interrupt you on the very last part, but I have a burning question. So
Go for it.
So I understand how SB 91 is put together. Part of it, so if somebody is trying to collect on late rents, they have to wait until the end of June. That's right, correct?
Yes. Well,
for now.
Yeah.
Right? Okay.
Yeah, I mean, there's exceptions. So if it's going to be small claims or like a regular civil action, there are two different deadlines, July and August, but summertime.
Okay, but the part I'm interested in is that the landlord has an obligation, I believe, to help the tenant get rental assistance through either state or federal assistance. Can you touch on that just a little bit, how that works? Just a few minutes.
Yeah, absolutely. That's coming up, I think, like 5 slides from now. So
Okay.
it'll be on the slides. I can get to it at that point. Otherwise, I can do a real quick.
No, we can wait. We can wait.
Okay, cool. Yeah, it'll be on the slide and maybe like 5 slides from now. We'll try to get through it quickly again, mindful of the time. I know it's 1 o'clock and we're close to wrapping up, and we again want to save time for questions. So I think Olivia is going to run through the CARES Act and the CDC.
Yeah, thanks, Anna. CARES Act, there was an eviction moratorium at the federal level that was passed on March 27, 2020. The federal eviction moratoriums could probably have their own 1-hour presentation on them, so we can't get into all the details of that. I guess the important thing to note is that there was an initial 120-day eviction moratorium. We're now past that period. And the important takeaway that's still in effect now is that if a property would fall under CARES Act protections, a 30-day notice to pay or quit is required instead of the 15-day notice under state law. And this is going to apply to properties that had federally backed mortgages or that participated in a federal subsidy program. So just be careful of that. Just as a practice tip, before you serve any notices, check in with your clients just to make sure that they don't have a federally backed mortgage or that they didn't participate in a federal subsidy program before you serve your 15-day notice, because you may need to use a 30-day notice instead. Okay, and then CDC moratorium. This is another one that's got all sorts of various provisions to it, so not one that we can necessarily cover completely right now, but just to quickly breeze through this one. It is effective September 4, 2020 through March 31, 2021, though, I think another extension is expected here. Tenants claim protection under the federal moratorium by returning a declaration, though it's a different declaration than the one required under state law. The tenant basically has to claim that they are financially impacted and unable to pay rent, and there's some various other requirements that will be included on the next slide here. And if the tenant claim that, then they are protected from eviction. However, certain fault-based evictions are exempt. And this moratorium basically applies when there's not a state or local moratorium that's more protective. And Anna, can you jump over to the next slide? So, I think for CARES Act, there is like I said, a different declaration that's required for that. And it's set forth in the statute. So if you receive a different type of declaration from a tenant, you might want to check the the CDC moratorium and see if it complies with that. The CDC moratorium may provide more protections to certain tenants that just for some reason are not covered under the state law. And so you do want to be careful that there's not a federal rule that's going to still prevent your eviction of a tenant, even if they and then Anna, do you want to quickly cover the courts?
Yeah, we just wanted to make everyone aware, what are the courts doing right now, and cases are going forward. We are seeing our cases move, but you've got to just really be careful about all of these requirements. And there is a lot of leniency for tenants if they are able to comply. And, always check your specific court local rules for further restrictions, city, county, state, federal levels.
Yeah, and just before we move on from that too, definitely check court rules. Some courts have really restrictive rules and are taking very limited UD actions, like Alameda County in particular. So even if you can get past all these other hurdles, you might still get stuck at the court level. So just watch out for that. Basically, every single level could have some issues. Okay. Just to really quickly touch on this judicial counsel form, just be mindful that if you're filing an unlawful detainer action in Superior Court, you, for some reason, were able to get past the hurdles of these various moratoriums and you can file, there is a mandatory cover sheet that's required now. You can find that on the California Court Forms website. It's got to be certified under penalty of perjury and it's subject to demurs, motions, all that kind of stuff. So make sure that your clients are putting correct information on there and that it is complying with all the legal requirements. There's also a list here of other updated court forms, so just look out for that. Complaints have been updated, answers have been updated. As a practical tip, I find a lot of these forms to be really convoluted now, and it may be easier to just use your own pleadings. The forms are just kind of all over the place and have a lot of boxes. They're kind of hard to use, so we rarely use them.
So JR was asking about this earlier. I'm just going to touch on it very briefly. SB 91 expanded the expansion, or I should say AB 88 expanded this and SB 91 extended it. So if you're a landlord and you want to go to small claims to recover rental debt, you can. The rent must have been owed between March 1st and June 30th. And it expanded jurisdictional limits. So landlords can go to small claims court for all of that, but you can't file your small claims case before August 1st of 2021. So don't go to court, don't file small claims, gotta wait till August 1st. And these jurisdictional limits are lifted all the way through July 1st of 2025. CCPs on the bottom of our slide. Similarly, lawsuits. So you don't want to go to small claims court, but you want to go to file a regular civil action, limited or unlimited. There's a lot of new rules that were implemented by SB 91, but you can't file that lawsuit before July 1st of 2021. And if you've already filed a lawsuit, then your civil action will be stayed unless it was filed before August 1st. And the defendant would not have qualified for rental assistance under this new program, which I will get into because JR asked about it. And the landlord must attach documentation to the complaint showing that the landlord or plaintiff made a good faith effort to work with the tenant first and seek governmental assistance. So that's a new requirement. This is a pretty big point. So definitely, look back at this slide before you bring a general civil action. Can't do it before July 1st. There are some other requirements. What I think is interesting is that SB 91 added a prevailing party attorney fee cap. So if your lease already provides for attorney's fees, SB 91 is going to cap that to $500 in an uncontested case and $1,000 in contested. So that's pretty interesting. It does not create a new right to attorney's fees where none otherwise existed, and there is an exception if you can prove that the case was unusually time sensitive or complex, or if the defendant, propounded a ton of discovery, took depots, really worked up the case, you might be able to get an exception to the attorney fee cap. SB 91, there are some other amendments. Rental assistance program, this is what I really wanted to get to. JR, this should answer your question. There is a whole new rental assistance program created by SB 91. It is available for households who meet certain requirements. The big one is that they must be at or below 80% of the AMI, the area median income, and the state. So this is federal money, but it's going to be distributed through the state. I think it's something like 150 billion in federal money going through California. And there's going to be a priority on who gets the money distributed in 3 different blocks. What I think is really important just to know for purposes of keeping our presentation concise and to the point, if a landlord has not been paid rent from April 1st of last year through March 31st of this year, they can get up to 80% of that rent paid through the state, as long as the tenants are qualified, and then the landlord has to forgive the remaining 20%. The funds will be available, or the application period opens on March 15th. So we'll be looking for guidance from the state as to when landlords can apply. But as JR pointed out, you have to, as a landlord, you have to work with your tenant to apply for this money. It will be administered through the state rental assistance program, and then there are going to be block grants to qualifying jurisdictions. The 3 rounds I talked about are up on the slide. So application period opens March 15th. First priority goes to households who make less than 50% of the AMI. Next round goes to communities disproportionately impacted by COVID-19. Round 3 goes to all remaining eligible households. So what I think practically will happen is, as long as the tenants meet the requirements, the money will go probably rounds 1 and round 2 quick, and then whatever's left over to the remaining eligible households.
So you know what, and Anna, you know what's really impressive is yesterday when we talked, you rattled all of that off the top of your head without looking at your slide presentation. Everybody knows this stuff. It's Anna, she really, and Olivia, of course, that it's really impressive how you know down to the last detail of how these state funds are going to be distributed and things like that. Can I ask you another question here from the chat?
Yeah, jump in.
So one of them, this is an interesting one. Like, what if there's a caregiver, like a living caregiver in this kind of situation? They're wondering if, AB 3088 and SB 91 are going to apply to somebody like that as a tenant.
Yeah, that's such a good question. I think we had a case on that same point. It's so fact specific, but to just try and touch on the answer, the caregiver could be a licensee. So they're staying at the unit, with permission under a license, they're not paying any rent. They could be considered a roommate of the tenant and there with permission. It really depends on what city this is located in as well. If the caregiver has paid rent directly to the landlord, that caregiver is a tenant now with tenant rights. So it's super fact specific, also depends on the city, but the caregiver absolutely could have protections, also could be considered a licensee.
And
Also, just to note on, I was going to say, just to note on that real quick too, there is a just cause that would allow termination of the occupancy as a licensee under AB 1482. So that might apply there.
Oh, I wasn't aware of that because Anna and I have talked about before a notice to terminate a license.
Yeah. And of course, it depends on what city and what county you're in too, because if there's local rules that do not allow that, they may conflict. So really depends where you're at.
Okay. And then, so the other subject we're going to change real quick is what foreclosure protections do landlords have if they're not able to pay their mortgage right now under SB 91? Could you touch on that just for a sec?
Yes, there is a whole host of foreclosure protections for landlords. Some of them apply to federally backed mortgages. If whoever asked that, want to shoot me an email, we can get into it. My email address is aliu@samlaw.net. It'll be up on the very last slide, but it's a pretty broad question. There are some foreclosure protections under AB 3088, but it's very fact specific. Fly through the new protections.
Yeah, I was going to say, there's a slide here that summarizes some of the new protections. I think just be aware that these are out there. Our materials do summarize each of them and also link to the particular code section. So if you're interested in more details of any of those, just check those out. They're on our slides. Basically, it's things like there's rules on collecting late fees. There's rules for how rent payments can be applied, basically which month rent payments can get applied to. There's rules about using security deposits for tenants who have missed their rent payments. There's rules about using COVID debt as a negative factor in tenant screening. Basically, that can't be done. Anna, you want to flip to the next slide? There's also new rules about sale and assignment of COVID debt. So basically that cannot be done until after July 1. And if the tenant is a low income tenant or lower income tenant, basically the landlord can never sale or assign the debt. The CCP sections are also cited too there. So check those out if you have more questions about that. And then there's also increased penalties for illegal lockouts and utility shutoffs. So again, check the civil code statute there. But if a landlord thinks they're going to get around these rules by locking the tenant out or shutting off utilities, there are enhanced penalties for that. So you'd be surprised, we've actually had some landlords asking us questions about whether or not they can do this. And so the statutes have increased the penalties for that. All right, and then finally, there's also an expansion of the retaliatory eviction ban. If landlords thought that they could come up with a different just cause that's not non-payment of rent and use that to evict their tenant, basically if there's evidence that the landlord is just using this other just cause to terminate the tenancy, that might give the tenant a defense. So that is in Civil Code section 1942.5. The retaliatory eviction ban has been extended. And then finally, just note that we kind of have a summary here of some of the main portions of SB 91 amendments. And as Anna mentioned at the beginning, I think there's about 20 different laws that have been altered by SB 91. So lots and lots of material. All right. Should we
Little pointers we'll fly through. We were going to give you some tips. I think we've kind of incorporated that throughout our presentations. JR, if you want to throw a few questions at us, we will leave our contact information on the screen. You can feel free to shoot us an email and we can talk with you. All the information today is in place as of today. These laws are constantly changing. So what we just told you could be changed next week. So just keep an eye out and also, just stay up to date on everything that's happening. There's our information. JR, if you want to shoot us a couple of questions, we can stay on.
Sure. I mean, there was a question just posed. The slide presentation, Anna touched on this earlier, and some of the laws that are referenced herein are part of the materials that will be distributed as part of this. Hey, can I ask one of you to go back to the practical tips slide?
Absolutely.
The thing I've heard more than anything is to for both landlords and tenants to try to work through this together. Seems like the overarching policy with the government, at least on the state level, is to preserve tenancies, right? They don't want a mass homeless population coming out. Is that what you would agree? Is everybody to try to work together to kind of prevent evictions?
Absolutely. Yeah. I mean, especially for a lot of landlords these days, there's just so many prohibitions on what they can do. And there's not a lot of options. I just got some questions yesterday from a landlord that wants to sell their property. And they said, there's all these rules in effect. Even if legally I can terminate the tenancy, why would the tenant actually leave? Why would they move out? And I said, well, that's a good question. And they're in a big time crunch to sell the property. So my advice to him was definitely, talk to him, see what you can do, see what sort of deal you can work out.
And so if somebody initiates an Ellis Act eviction, but then they don't actually have to get a judgment on it, is there a prohibition on actually renting out the place again, even though you didn't get a judgment on Ellis Act? Sorry, that's a kind of a loaded one, but.
Anna, do you want to tackle that one or should I?
Sure. Yeah, Olivia is the go-to for Ellis. Olivia knows her Ellis cold. If you serve an Ellis Act notice and you record the memorandum of notice of constraints with the state, those Ellis Act restrictions are tied to your property, even if the tenants don't vacate and even if you don't get a judgment, is the short and sweet of it.
Yeah, one thing I'll add to that too is there's a difference between local governments who have Ellis Act eviction as one of their just causes under their local rules and how basically their ordinance matches the requirements under Government Code Section 7060 and the following sections, the Ellis Act. And then there's AB 1482's withdrawal of the property from the rental market, which sounds a lot like the Ellis Act. However, a lot of states and counties do not have all the procedural requirements set up to allow a landlord to, file memorandums of notice and do these other things that are required under Ellis Act eviction. So just as a practical matter, I think if you're serving a notice under AB 1482 for withdrawal of the property from the market, and there's not a local ordinance that requires a specific Ellis Act eviction, you may be able to get around that stuff. I served a notice not that long ago for a property up in Sebastopol in Sonoma County. There's no rent board up there. There's no just cause ordinance that says that I've got to do all these filings with a rent board or anything like that. So I think we're just looking under state law, withdraw the property from the rental market, and there's no specific rules. So I tell my client, don't re-rent. I mean, if you re-rent right afterwards, You could be looking at a wrongful eviction lawsuit. How long do you have to hold off on re-renting? I don't know. That's not answered by the laws, unfortunately. So I think that's going to depend on court interpretation of these rules as more AB 1482 evictions end up in the courts.
Great. Well, it's well over the time. Your time is incredibly valuable to us all. Like yesterday, we had a presentation for the California Lawyers Association and inundated with questions about this on a state level. And I appreciate everybody's enthusiasm today. Both Olivia and Anna, thank you so much for your time and knowledge and expertise here. So thank you very much. Ann, did you have something to add?
No, that was just amazing. Thank you very much for all of that. I know everybody was very excited to get this information sort of clarified and laid out as best we can, given the date and the rapidly changing landscape. So thank you guys very much. And everyone will get those presentation materials and certificates out to you as soon as we can. Thank you, everyone. Have a wonderful day and a great weekend.
Thank you
for
for having us.
Thank you. Uh-oh.